right, so this morning I've got two of my guests already in here. We are going to start the discussion right away. I'm not going to read my take to you. Go to my Joy online and check out my take. Very interesting subject matter that you will like to read about. I'm talking about the possibility of suing charlatans who parade in the name of prophets and give doomsday tragedy prophecies under the cloak, as it were, of religious freedom. I make a case with sufficient legal authority that one ought to be able to sue them for them to pay heftily in damages for shocking you and causing the fear that they cause with their public declarations of doom. So go to my Joy Online, it is on there right now, and read my take. It's titled, Ebony Shatawale Sue the Charlatanic Prophets. Right. So, my guest this morning, and interestingly, key actors on the committee that has probed and issued a report on the cash for seats, will do an interesting discussion on the show this morning. And in the studio, Yao Boabeng Asamoah, he's MP Adentan constituency, and he is a lawyer. Good morning and welcome.
Thank you.
This will be your first after the elections, I suspect, because I don't recall having you back in the studio after the elections.
Since you became a member of parliament.
Yeah.
Okay. No, you have.
Yeah, I have been
You
here.
have. You have.
I have been here.
You have. I remember that. You have. You have. Welcome and good morning.
You know, Kwaku always had the documents.
Right.
He confirmed it.
Right. Because I remember congratulating you when you came here, and you two giving a message of thanks to your constituents.
Right.
Okay. Also here in the studio is the MP for Asawase constituency, and who is the minority chief whip in Parliament, Mohammed Mubarak Muntaka. Good morning and welcome, Honorable.
Good morning.
Also in the studio is Abdul Malik Kwekobako, editor-in-chief of the New Crusading Guide newspaper. We should be joined shortly by Dr. Dominic Ayine, who is MP Bolga East constituency and ranking member, Legal and Parliamentary Affairs. Of course, he was a member of the committee that Boabeng Asamoah was on. And you heard Boabeng Asamoah doing his legal best, at his legal best on that committee, eliciting definitions that got people wanting. On the phone lines, we will be speaking, and I'm sure we have him on the line right away. We'll be speaking to Professor Stephen Kweku Asari, who is in the United States of America. He's a Ghanaian and has been waging battles at the Supreme Court. And one of his recent battles at the Supreme Court is what resulted in an order of the Supreme Court to the General Legal Council, the body that regulates legal education and legal profession in Ghana, ordering them to take steps to do certain things because they had been engaged in some unconstitutionality in the manner in which they had conducted, entrance exams and interviews for candidates to the Ghana School of Law. Prof, good morning and welcome to Newsfile.
Good morning, Samson. How are you?
I'm good. Thanks for asking. Prof has been speaking on a number of issues, but he's on the show this morning to speak to the matter that we all know he is at the forefront of the crusade. That is for the expansion of the law school so that there can be more people who can get access to become lawyers. But he has spoken about Martin Amidu's nomination and vetting process. He's actually asked the president to revoke the nomination. Then he's also encouraged and spoken in some way commendation to Dr. Raymond Atuguba for the research that he has done. So we'll engage him on these three issues briefly, and then we'll return to the studio to continue with our discussion here. Now, Prof, first, you say President Akufo-Addo should revoke the nomination of Martin Amido. Why so?
Thank you very much, Samson. The reason is very simple, and I'm surprised that it escaped the Attorney General as well as the legal staff at the Flagstaff House. As you know, Article 191 talks about retiring age and pension. And in both jurisdictions, pension is a matter of statutory law. But for whatever reason, the framers of our Constitution from 1979 have thought that pension is so important that they've elevated it to a constitutional matter. And so we must take their ethics seriously. When you go to Article 199.1, it tells us that a public officer shall, except as otherwise provided in the Constitution, retire from the public service on attaining the age of 60 years. Now, as that typically, there are certain exceptions granted by the Constitution itself. So, for instance, if you are a high court judge, you are supposed to retire at 65. If you are a justice of the Supreme Court, you are supposed to retire at 70. If you are an appeal court judge, you are supposed to retire at 70. If you are a chairman of the Public Service Commission, you are supposed to retire at 70. If you are the vice chairman of the Public Service Commission, you are supposed to retire at 65. And in 1996, I believe, Article 199 was amended and a slight exception was made to the public service retirement stage. But that slight exception in itself doesn't waive Article 199.1. It only makes an exception. So we can get to that. But the gist of this thing that I've gone through is that if Mr. Martin Amido appointed to be the special prosecutor is over 60 years, then he's constitutionally disqualified from holding the office. There will be no way to massage the Constitution to make his service possible. A lot of people may want him to be the special prosecutor because he's very qualified. I happen to be one of those people who think he's qualified for the job. But I also happen to be one of those people who think the Constitution should be followed. It should never be set aside for a temporary expedient.
What do you say? What do you say to those who say that Section 13(5) of the Special Office of the Special Prosecutor provides that the terms and conditions of the Office of the Special Prosecutor shall be the same as the Justice of Court of Appeal? And you have just noted Article 145 of the Constitution says a judge of the Court of Appeal retires at 70. What do you say to those who say that grants him an exception?
Something. Parliament should be extremely careful when it goes to copy things from the Constitution and put them in the statute. Just because the Constitution framers could do something doesn't mean Parliament can also do the same thing. So I'm going to say two things. First, if Parliament is just conferring a right that is already granted by the Constitution, that is not a problem. Second, if Parliament is distracting from a right that the Constitution has not taken away from somebody in the statute, that is unconstitutional. So you quote the one on this, but before I get to it, let me talk to you about Section 13(1)(e). Section I'm afraid that will be unconstitutional because when it comes to taking political rights away from people, it is only the Constitution that can do it. Just because you see it in the Constitution doesn't mean you can really copy it and then just apply it. So when you're going back to the terms and conditions of an appeal court judge, you see that there's a general rule in the Constitution about retirement age, and the Constitution itself makes an exception for appeal court judges and Supreme Court justices. It doesn't mean Parliament can write a statute and say, well, this person has the same terms and office as an appeal court judge, and therefore we are waiving the requirement of Article 199(1). No, Parliament does not have the power to waive the requirements of Article 199(1).
Okay.
And merely saying that somebody has the terms and conditions of an appeal court justice doesn't waive anything in the Constitution. It is
okay. How about the critical point being made by others, including Maxwell Opoku-Agyeman, Bright Simmons, and I think some other people who suggest that if you look at the Special Prosecutor's Office of the Special Prosecutor, it does look like there's a compelling argument that it is not a public office. You ought to be in a public office to have the retirement age applied to you. It is not. What do you say to those who also say we have diplomats, among others, who do service for this country, who are beyond, 60, 70, and so on? What do you say about that?
Yeah, I'm afraid mistaken because, of course, we have different shades of public officers. The president himself is a public officer, but we have public officers who hold elected office. They are exempt from this retirement age requirement. We have public officers who are appointed by the president to help them discharge executive functions. For instance, ministers and deputy ministers. They are exempted from this requirement. Public officers who fall under 190 are those who are protected from arbitrary dismissal and can only be dismissed with cause. Now, Parliament, what it did with the setting up of the special prosecutor was to set up effectively a public corporation that comes under Article 191(b). Because when you read the Special Prosecutors Act, it says it's a body corporate. What is a body corporate? A body corporate is just a public corporation. So 199(1)(b). The only exception that 199(1)(b) admits of is a public corporation that is set up as a commercial venture. As far as I know, the Special Prosecutor is not set up as a commercial venture. So that exception will not be availing to that office, I'm afraid.
The argument that by the architecture of the Special Prosecutors Act, the appointment procedures and all of those suggest clearly that this is a specially designed vehicle that departs from what will constitute a public office, you say, will not wash. Now, on the basis of that, you said the president should revoke the nomination?
Well, I mean, not only should the president revoke the nomination, but I don't think the nomination will go anywhere because if the Supreme Court reads the Constitution as it's written, it's not even complicated. Not, I mean, there's really no way you can read the Constitution to accommodate the exceptions that...
And I need to state here that we ought to stay away from that. In seeking to predict what the Supreme Court ought to do or not do. So you are simply saying that there's no basis for the president to keep him. He should revoke his nomination.
I'm even surprised Mr. Martin Amidu subjected himself to the vetting, given that there was a pending Supreme Court case that raised substantial legitimate issues. I mean, he himself has raised questions about whole parts of the Special Prosecutors Act And I believe we are going to see more litigation about the Special Prosecutor's Office.
The Parliament was not a party, so Parliament was not connected to it. So they could go ahead. They were not a party.
I understand Parliament could do it, but I'm talking about Mr. Martin Hamidu himself.
Okay.
Martin,
by what we know, he had not been served with the writ or the processes by the time he was in Parliament.
Very well.
Okay.
I'm not going to go into that.
Thank you. Thank you. Now let's move to matters of the General Legal Counsel and legal education. To start with, Dr. Raymond Atuguba suggests that the General Legal Counsel has disobeyed the orders of the Supreme Court, and that by the Constitution, such disobedience ought to attract, jail terms of 10 years for the members. Do you endorse that point of view?
I endorse the point of view that they should be held accountable for violating the Constitution. The Supreme Court has said that the members of the General Legal Counsel have violated the Constitution. And we cannot live in a country where an administrative body can violate the Constitution without consequences. When we say something, we must mean what we say. The law on admission to the School of Law is very clear.
Now, before we get to the law and the process as you took to court, why would they have been said to have violated or disobeyed the orders of the Supreme Court, which the Constitution says constitutes high crime? Why would they have been said to have violated the orders? Because they were given 6 months, correct? And can you demonstrate that they did not place their legislative instrument in Parliament before the expiration of 6 months?
Well, I interpret the order of the Supreme Court very differently. The Supreme Court basically said to them that, look, the way you should make policy, legal policy, is by regulation.
Okay.
You cannot make policy by administrative steps. So if you want to change the way that you admit people to the School of Law, number one, it has to be consistent with the Parent Act, which is the Legal Professions Act 32. Number two, you must do it by legislative instrument. But people must plan their lives. So you must give people notice. So if you want to change the law that will govern admission in 2018, make sure you've done that by December 22, 2017. Now, it doesn't mean the General Legal Counsel, they have to do it. They have to change the law. The General Legal Counsel may very well say, we don't want to change the law. And if they don't change it, then LI 1296 will be the governing law for admissions for 2018. Frankly, in my view, it should be the governing law for anyone who has started the law program this year until they all get out. So by not giving us a new LI by December 22, 2017, it means for 2018, LI 1296 will be the law that governs the admission of students. So the notion that they violated that 6 month rule or 6 month window, I don't necessarily agree with it. My interpretation is because they haven't done anything within that 6 month window, then LI 1296 continue to be the governing law. We already have a law. We have a law in place. We have a regulation in place.
Right. What is your understanding of what the orders of the Supreme Court were as regards what ought to be done? It's not the same as what the General Legal Counsel has. When they appeared before Parliament, they clearly articulated that they were required to place an LI to legitimize what was illegitimate, if they so desired. And they have placed an LI before Parliament. And here you are with others crying hell that Parliament should not allow that LI to pass. What's your basis?
Several. Number one, of course, as I said, the Supreme Court itself cannot order the General Legal Counsel to go and place an LI, and because the ultimate disposition admission of an ally is up to Parliament. So for the Supreme Court, somebody to say the Supreme Court has ordered us to bring you an ally and you must therefore accept it, that is just logically incoherent and inconsistent.
The Supreme Court, by the exercise of its consequential
Pardon?
powers, by the exercise of its powers to make consequential orders, is able to do so. But you proceed.
Yeah, I mean, the court has the power to issue orders, but the order itself must be interpreted reasonably.
Okay.
If the LI has to be laid in Parliament and Parliament can annul the LI, then the court asking someone to go and put an LI, what does that mean?
They would have done their job.
Parliament annuls it. That's not the order. That's a misinterpretation of the order. Then the second thing is that the court made some declarations. In Ghana, unfortunately, people tend to fixate on the order and forget about the declaration. The declaration itself is consequential. If the Supreme Court says you have done something that is unconstitutional, it is not just vanity. It means something. It means you have to stop what you are doing. It means if you have created any victim in your unconstitutional action, the victim should duly compensate them. And in the case of in the case that we took there, the court made 3 key declarations. Number 1, the entrance examinations and interviews were unlawful. The imposition of those activities were unlawful. Number 2, everyone in Ghana who has an LLB from an approved university automatically qualifies for admission. And number 3, people who had been previously disqualified were unconstitutionally disqualified. Well, what does that mean? That means if you were previously disqualified, you can just show up and tell them, hey, admit me this time. Now, if you go to West African Exam Council versus Awuni, the same situation happened there, where the West African Exam Council unconstitutionally disqualified certain students from taking an exam or at least try to bar them for a certain number of years. The Supreme Court said, no, you can't do that. You have to follow your regulations. Not only do you have to follow your regulations, we are going to award 5 million cedis to each student whose rights you violated. So there's a cost to violating someone's constitutional rights. Now, in my own case, I went there for a declaration, so I couldn't seek damages.
Right.
But I'm telling you right now that all those students who have been victimized, the 3,000 students who have been victimized, they should bring a class action lawsuit seeking monetary damage from the General Legal Council. In addition, of course, to being admitted automatically.
Okay, maybe because you are not within the jurisdiction and you don't practice here, you would have been guilty of instigating litigation by calling on them to go and sue in the manner you are suggesting. But we need to do this and do it a bit, clearly and briefly. Canvass your points why the law school should not remain what it is now.
Well, it's not me who is saying this. Anyone who wants can go and read the legislative history of the School of Law. The School of Law was never set up as an independent school with its own admission rules. It was set up as a finishing school for law graduates. President Kwame Nkrumah appointed a commission, a very competent commission made up of a professor from Australia, a professor from UK, and a professor from United States. They studied the situation in Ghana and rejected the clean approach that is used by UK. They rejected the trading approach that is used by the US, and they considered and rejected the German approach. So they said for Ghana, we should have a homegrown solution. And that homegrown solution was that everyone who wanted to be a lawyer should be trained at a university. At that point in time, only University of Ghana was training lawyers. And when they are done, they go to finishing school at the School of Law. At the School of Law, they were just supposed to take bookkeeping, conveyancing, and the School of Law was conveniently located near the court so that they can be visiting the court to observe what is going on. So when you are admitted to a law been jointly admitted to the School of Law, subject to being of good behavior, passing certain courses, and getting the LLB. So that is the spirit that informed the Legal Profession Act. And I'm submitting that the General Legal Council cannot revise that into a legislative instrument. So the legislative instrument that they are seeking to put there to put entrance exams, in my opinion, offends the Parents Act. And they really have to understand the history of the law school and the School of Law to be able to know what is going on.
It's what you are preaching best practice. The current mode you are suggesting ought to be the way by which people gain entry, which was the old system, which by the same regulations and laws allowed that after completing your course, your LLB course, you had automatic entry. Now, obviously, the numbers were low at the time. We are told of the first batch, which was, how many, is it 6 people or less than a dozen people? And then subsequently, about 100, then moving on to 200 maximum at a point. Because of the changing trend and the need to increase the numbers, they have opened up, increased to 400, and have even increased to 600 or 600 plus. They have set up 2 new satellite campuses in Gimpa and at the KNUST. What again do you seek?
This is why I'm telling you that the Legal Profession Act was done competently. When they wrote the act, they didn't say law graduates should just go to the School of Law. They said law graduates should go to the School of Law or alternative places of instruction. In our current situation, the simple solution, in my mind, is to dissolve the distinction between the academic law courses and the so-called practical law courses that are taken at the School of Law, and then allow students to take all their courses at their respective faculties. When they are done with taking the courses, they simply apply to take the bar exam, which should be administered by a board of examiners. So maybe twice a year.
Where in the world?
The exam is offered.
Where in the world do universities, give professional, as it were, degrees or get to call people to the bar?
The U.S.
Oh, that's not what I'm saying. I'm not saying that.
US.
I'm saying when.
No, best practice is that you have the exits and either the entrance and the exit, processes. They are using one of such processes, and you are kicking against that.
Yeah, but so listen to me. What I'm saying is, the universities should just teach the courses. When you get your LLB, you apply to take the bar exam with the board of examiners under the General Legal Council. So the General Legal Council will be responsible for bar examination, and the universities will be responsible for curriculum administration and curriculum delivery. The universities will teach the courses. This is what is done everywhere in the world. This is what is done everywhere in the world. Let me say something very quickly, about this entrance exam that we give. People tend to call it entrance exam, but it's not really an entrance exam. It's just a device to pick 300 people or 400 people. Nobody knows what it takes to pass that exam. They don't have a pass exam. They don't have a passing grade. They don't have a failing grade. Why? Because it's not really.
Well, we know they have a passing grade, and we know that they actually downgraded that recently, and still the students that were churned out by the various faculties didn't meet the downgraded grade. Even that, they couldn't get the sufficient numbers.
Something, please listen to me. What they have is they set a grade, a score that allows them to take a certain number of people. So this year they may decide, well, we can only take 400 people. So the students with the highest scores, up to the 400 highest score, are admitted, and the rest are left go home. It doesn't mean the rest failed the exam. They didn't fail the exam. There's just no space, and the saying that there's no space is just completely artificial because there's space. All the universities can accommodate accommodate all
but they have been concerned genuinely about the standards, that some of these faculties actually do not have the requisite standards to train lawyers. So you want them to just open the floodgates, and then, like some have said before, that lawyers like doctors can kill. A bad lawyer can kill.
Something. Again, this is a good point you are raising, and I want to clarify. I'm not saying that people should automatically be made lawyers. People should understand what I'm saying, that I want law graduates to be given the opportunity to take an exam to demonstrate whether or not they should be called to the bar. I'm not saying anyone should automatically become a lawyer. What they are doing now is to give you an exam, and based on the exam, then they tell you whether you are qualified to take another exam. That intermediate exam that they are giving is what I'm calling completely unlawful.
Take my very final question on this. My very final question on this is that the independent examination body that you have been against, if you are asking that the General Legal Council should, regulate the exam, how else are they going to do it? Are they not going to do it through the same process you are against? And again, what is this? If, as it were, you are able to go through the process and they open the floodgates, as it were, like the way you are suggesting, and they also say it is not the best. How can you guarantee that you are going to have the best of attorneys for the country?
Because you don't come out automatically unless they are telling you they have no way of taking an exam which will weed out those who are not good. Then your argument will be plausible. Your argument is not plausible at all, because people who go to the school of law or who go to an alternative place of instruction, they have to take an exam. Let me just illustrate with accounting, because I'm an accountant.
Yeah, do that very briefly.
When you are done with your school of administration or business school, you take the ACCA. Anybody who has a degree can take the ACCA. But it doesn't mean there's a floodgate of unqualified accountants practicing in Ghana. No. Everyone who is practicing as an accountant in Ghana is highly qualified. But everyone who has a first degree in accounting has the opportunity to take the accounting exam. The Institute of Chartered Accountants will allow you to take the exam, and that's where you demonstrate your competence. Competence and quality is not something that you sit on air and talk about on Facebook.
Okay.
So if somebody is not competent, you will find out when they take the bar exam.
Okay.
Why are they so afraid of giving people the opportunity to take the bar exam?
Okay.
And that's the question you should be asking them. Why are you so afraid of giving people the opportunity to take the bar exam? If it is true what you are saying, that they are not very good and their schools are not very good and so on,
okay.
We will know that
right. Okay. Thank you very much. But the General Legal Council have made it clear that they have actually acquired, plots of land to develop and to open up and expand. The system you are calling for now does not exist, and you are saying they should do that immediately. Also, that is going to be chaotic.
I'm not saying that. The law is saying that. What you keep saying, I'm saying that. It is the Legal Profession Act and LI 1296. They are saying that. Who am I to say something?
Okay.
I'm only stating what is in the law.
Right. Thank you.
When you say I'm saying something, please rephrase that and say the law says you should do this.
I hear you.
The General Legal Council is not about the law.
I hear you, sir. Now
let's go to Raymond.
Yes.
Let's go to Raymond.
Yes, and you're going to do that also briefly, but just hold on. We play this interview, interview of Raymond Atuguba, or presentation that he did at the GIMPA, at the Faculty of Law, when they organized the judiciary, 60 years of the judiciary, and what they had to discuss, and the presentation that he made. There's a portion of it. We play that. You comment briefly on that, because we have heard you comment already about that, and then my guest will also zoom in on that as well. So let's listen to Dr. Raymond Atuguba.
It's not about the integrity of the judges. No, this is not about judicial integrity. All I'm saying is this. I took 100 political cases analyzed the voting patterns. The voting patterns coincided with the parties who appointed them to power. I shouldn't be answering the questions here. Someone else should be answering the questions. It is not a coincidence that this happened. To convince me that it's a coincidence, you need to give me arguments that it is a coincidence. So, for whatever it's worth, let's put this analysis in the mix and try and improve the debate around the justice system. I would never insult anyone, not to talk of judges of this. No. I cannot do that. I'm engaged in the critical analysis of our political institutions. And critical analysis always meets opposition. So it's not an insult, it is just putting out analysis there from which we can improve our democracy. So the question I have for you is, what should we do with these analysis? Should we stop doing them? Should we have another way of funneling it to the public? What should we do?
Right, so that's Professor Raymond Atuguba, the Associate Professor at the University of Ghana, and he was addressing judges of the Superior Court at a function at Gimpa in the course of the week, and we'll shortly also let you know the reaction. I'm sure some of you are already aware the reaction by the Chief Justice and other judges who were there, and of course Justice Jones Doche said what he did was an insult of the highest order. Now, Professor Kwekwasari has commended Professor Atuguba, and what's your point of commendation, sir?
That he's doing empirical research. You know, people are always speculating, and it's useful that somebody will bring empirical data to either confirm what they're saying or disconfirm what they're saying. Now, frankly, what Raymond was saying is hardly surprising. It doesn't surprise me. It is consistent with what many people already say. For instance, a lot of us have been campaigning that they shouldn't allow the Chief Justice to pick the panel to sit on cases. Well, why do we say that? The reason we say that is because it is very easy to know a particular judge's judicial philosophy. And if I can know it, then the Chief Justice can also know it. And the Chief Justice can choose 5 people that will guarantee an outcome that will be very different if he has chosen a different set of people. And so what do presidents do when they appoint members to the Supreme Court? They don't appoint members randomly. The president assembles a legal team, and the legal team will go and read everything that the judge has written. And then the president will evaluate the judicial philosophies of all those people. And the president will naturally appoint people whose judicial philosophy are consistent with his own view or her own view of how the Constitution should be interpreted. So should it surprise people that...
Some ask the question, this is a very dangerous thing to do, and more importantly also because some question the logic that because of the absence of unanimity of the judges on a matter, which is a political matter, it means then that, you know, they are doing something because of their political, you know, philosophies, or what?
Yeah, I mean, look, judges are human beings. You know, we should get serious. Judges are human beings, and they bring to the question of judging their experiences, their, you know, the reaction with people, their interaction, and so on. So when they write opinions, it's going to reflect their own philosophy. Now, look, I go to the...
No, but when they write opinions, they give you reasons for each opinion that is taken, because they are enjoined by law to give you reason. And the reasons they give are undergirded by law. So what's the point? He says that where there is no clarity in the law, that is where the judges appear to express, you know, their political, you know, persuasion through the judgment. Is that a fair, you know, analysis?
But that's what I'm telling you, that the law is not arithmetic, where you can add 2 plus 2 and everybody will say 4. When you take a legal matter to the court, people are going to read it with their philosophical lenses. That's why in many cases you have 5-4, 4-3, 4-7, and so on. That's why you have a majority opinion, you have minority opinion. Now, if the majority versus minority is just based on careful, neutral evaluations, then if you look at 100 cases, as Raymond did, you wouldn't find that people from the same political camp or maybe appointed by the same president align consistently. The null hypothesis here is that there will not be an alignment consistent with the president who is appointing them.
Don't you take
and his data reject that null hypothesis.
Don't you take the Chief Justice's
surprising.
Don't you take the Chief Justice's caution, and this is my final question to you, we can be brief about it. Don't you take the Chief Justice's caution that this is, call it the American jurisprudence, that is going on here. Here in Ghana,
what is American about that?
Here in Ghana, we have a fledgling situation. The people, the level of education and all of that is not as much as you have in these places. So this can be very dangerous to do.
What is the danger? What is the danger in the same judges who are telling us we need quality education are now telling us we shouldn't do research because research is a danger to. It doesn't make any sense to me. Research is extremely important, and academic freedom is guaranteed. It is highly improper for judges to go to a university here, GIMPA, and attack academic freedom. Academics are free to say their mind, even if they make people uncomfortable. That's what is going on here. And again, I come back to my main point. What Atuguba is saying is hardly controversial. If I were to go to court tomorrow and I'm asked to pick a panel, I'm going to pick a panel because I've read their opinions and I know how they think. I'm going to pick people who I think are favorable to me. What's wrong with that? All he's saying is presidents know the judicial philosophy of the judges that they appoint, and it shouldn't surprise anyone that when the judges sit on the court,
thank you very much indeed, Professor Stephen Kweku-Asare. Professor Stephen Kweku-Asare has been very, very vocal on these 3 important issues that we have gotten him to canvass this morning, particularly his crusade for what has been termed as opening of the floodgates for legal education in Ghana, because he insists that there are so many people who are running out of Ghana, and that just yesterday he actually showed photographs where he says about 32 Ghanaians have gone to Rwanda and they are seeking the law school education there so that they will come to Ghana to practice. They will be called to the bar there, and when they come to Ghana, there's a very short thing we call post-call. That one, it doesn't appear there's a limit for the numbers of people who get to do it. So people go outside, they do that, and they come back and do it. And he's saying that many Ghanaian students who have done LLB are going to the UK, going to elsewhere to do them and come here. And that's a lot of foreign exchange. If we did our things well, we can cash in on that. Well, the General Legal Counsel says they are interested in expanding, but they are presently constrained. We will take a break here, and when we return, my guest will deal with all these 3 important matters in one legal discussion. We'll be right back. You're welcome back. This is Newsfile. This is your most authoritative news analysis show, and we're just done with an interview with Professor Stephen Kweku-Asare, who's based in the U.S., but is heard loudly in Ghana almost every day. Yeah, right. And there's some information correction that I'm supposed to do, that the Ghanaians who do the LLB in Ghana and go to other African countries with the same common law jurisdiction that we practice and do the the law school there, when they come, they don't actually do a post call. They just apply and they get called because they would have satisfied all the courses that are done for the post call. Except that it is those who do it elsewhere in the UK and elsewhere, they would not have done all the necessary courses that are required. That's the information I'm getting. So, in other words, they are dribbling the Ghanaian situation. You're right. Okay. So, Dr. Dominic Aine, good morning, yes, and welcome.
Thank you very much.
Right. So, maybe I should start with you. What do you say about how Professor Kwaku Asare and people like him see the situation? Now, we have heard Honorable Yunusa Fuseni, among others, who suggest that something can be done. There are others who also say, look, what you are proposing is not feasible, at least in the immediate, term. So let it go.
Thank you very much. When we were in government, I was one of the dissenters of the system. In other words, I support wholeheartedly the position that has been taken by Prof. Asare. And I've written extensively on this matter. One of my articles on it was published in the Daily Graphic, the Graphic recently. I actually, proposed to make a statement on the floor of Parliament, and I submitted it to leadership. The statement never saw the light of day. Subsequently, when I asked why, I was told, that the speaker was a bit worried that some of the things that I said in that statement would offend the judges. I didn't think so, because I was simply trying to point to the fact that there was a need to take the judgment in Asare and Attorney General on this issue, very seriously, as a starting point for, radical legal reform of the professional legal education system. Because we are in a crisis, and the crisis that has been brought upon us, and especially the young people who are aspiring to be like us, on account of lack of planning and foresight. Okay, this is just a failure of planning. There's not, I mean,
okay, so tell us in practical terms so that everybody can understand clearly what ought to be done differently from what pertains, which the LI is seeking to legitimize.
Well, as the professor has said, okay, the drafters of the act made it very clear that you can use alternative, institutions of instruction. So, as a starting point, if the Ghana School of Law is, lacks capacity to be able to absorb all of these, they can use alternative schools of instruction. And I was thinking that in the article that I wrote, I actually pointed out that you could actually start with the law schools that award the LLBs, okay, the faculties that award the LLBs. Let all the practical courses that you are talking about be taught in those as clinical programs. And then afterwards,
those law schools, law faculties, we have almost about a dozen now, right, in the country?
Yes.
Okay.
Yes. So the proposal is that they can serve as the alternative, schools of instruction in addition to the Ghana School of Law, and let them teach clinical courses just like the law school is, teaching the practical courses, and then let the students write a common exam at the end of the day, okay, and that will solve the problem. Once and for all.
You don't appreciate their concerns of the capacity of these other schools and the quality. A major concern is the quality.
Samson, in 2015, I addressed the Ghana Bar Association National Conference in Kumasi.
Yes.
And I took the liberty, to address this issue. And I said, and I'm going to repeat that.
Including quality of judgments by judges.
Yes, yes. You see, when a person has been taught by Professor Kumado, okay, one of the leading authorities on constitutional law in this country, and he's roaming the streets of this country, seeking to enter the law school, I think it's unpardonable. For you to say that that student is not qualified, to write the professional legal exam, for me, it is something that is unacceptable, okay? Because the quality of training at the Faculty of Law, where I taught, okay, the standard is so high, right? But there are Faculty of Law, University of Ghana students who have been seeking to enter the law school for 3 years consecutively, and they have not been able to do it. So how do you explain that? So you don't just take one example of a law school that is not very well organized, whose curriculum you have, I mean, the teaching, the quality of teaching you have problems with, and you say that that is, you know, you take an outlier case and say that that is, you know, the basis for you to say then that the quality of training in all law schools is so bad that you cannot you know, allow them to.
Giving you an example of where they had to lower the score that they were looking for.
You
They
see,
lowered it, and they still couldn't get the numbers.
that is
Even when they had opened up, they were ready to take up to 600. They lowered the score, and they didn't get the numbers.
something. The problem is the system itself that they are running. If you have a situation where the students don't know, okay, how the questions are, you know, I mean, are set, or where they are going to be set from, whether it is in the area of constitutional law, the law of contract, equity and succession, and so on and so forth. And then you set 5 questions out of 9 subject areas. Okay, no one, no, I'm just astounded by what is happening, because it is not, I could fail that exam, seriously, okay? And it is not because I'm not intelligent enough to write the exam, but it is the manner in which they are running the system. I'll give you the example of Kenya. In Kenya, okay, the law actually specifies the subject areas, okay, and then the examinable, you know, I mean, subject areas for the students. So you know ahead of time what you are supposed to do in preparation for the exam. In our case, we don't know. Okay, so the independent examination body says these questions, you know, surprises the students. Most of them go in and then they fail. And you say that as a result of the fact that they didn't do well, you are lowering the grade. It's because of your own lack of diligence. It's because of your, I mean, inability, you know, to do a good job.
Okay.
That is why the students are failing.
Okay, so in a minute, tell us, is it practically possible what is being proposed as the alternative within this immediate term?
I think so. I think so. I think if they, for instance, decided that the law faculties should teach those practical courses, and then the students should take a national exam, all the law faculties should be ready
These are
to
faculties
do
that are already stressed. Some of them are getting closed down because they don't have the requisite number of teachers.
So you close the ones that you close down, and then those that you think they have, you know, the quality standards to be able to do this, they should go ahead and do it.
Interesting. Yes, Wabi.
Taking off from where you left off.
Yes.
Yes, I sincerely don't think the medium to long-term solution can be immediately implemented. I'm a member of the subsidiary legislation committee. Actually, I'm the ranking member on that committee. And I feel the emotions and the tensions. I've listened to the students and everybody. Indeed, the best we can say for the General Legal Council is that they've been tardy. They've waited and allowed this to overcome them. And therefore, they are caught flat-footed. Because you're talking about standards, and we all agree that standards ought under no circumstances be compromised.
Right.
And yet, if you allowed successive universities to be accredited to offer LLBs,
they are not in charge of accreditation.
that is the question.
That's not the General Legal Council's business.
That is the question. Ought there to have been some sort of collaboration between the General Legal Council and the accreditation board? That's one of the questions why I insist that
if someone applies,
yes,
if someone applies for accreditation and they meet the qualification criteria provided by law, the National Accreditation Board cannot say no. And the General Legal Council cannot dictate to them that if they come, expect this extra, you know, things. Otherwise, they'll go to court and throw them away.
But it is one of the subtle reasons that the GSE is proffering for having an exam, that they can't vouch for the quality of the LLBs they are being asked to admit. Apart from the other 2 reasons they are giving, that they are short of faculty, quality faculty, and that they are short of infrastructure. But you cannot say numbers compromise quality necessarily.
Yeah.
You can't say that. That argument is not tenable. Neither can you say that a paucity of faculty and infrastructure should restrict people's rights to an education if they can afford to meet the qualification criteria. The nub of the matter is whether or not the qualification criteria as it stands enables all the people who are supposed to have qualified to
Yeah,
enter.
so now the about a dozen faculties are producing in excess of 1,000 LLB students, and only 450, or as they are trying, 500 plus are being admitted. Should this still remain the solution?
No, I think that the media likes to call it a saga. I think this gives us an opportunity, and we've told the GLC ad nauseum. I would have loved to see them even now convene a national stakeholders conference on this matter in order to restructure the entire phase of legal education. At 32, it's probably older than me.
Yeah.
I was born in 64. At 32 is 60. It's too old. It hasn't seen, but it's a very resilient piece of legislation, except that it still needs to be modernized, given the numbers, given the new needs, given other considerations. They must move swiftly. But I'm saying that in the interim, even moving to changing the architecture is a medium-term situation. And we are looking at 12, 18, 24 months probably.
Okay.
Within that period, I expect that an airline must be put in place to regulate the process for now.
In the meantime, you are saying that this airline must...
No, in the
survive.
meantime, to the extent that, again, there's a certain emotiveness about the current LI.
Okay.
I think we must go back and interrogate the Supreme Court decision.
Okay.
And happily for all of us, June or July 2017, I think the High Court Justice Anthony Yeboah did a superb analysis of the decision. And I love the way he put it.
Okay.
He said that notwithstanding the unconstitutionality of the actions as declared by the Supreme Court, the Supreme Court also put in a condition.
Okay.
So it's a conditional unconstitutionality. So the condition is that, yes, that's the word he used, conditional unconstitutionality. And therefore, there's a window of opportunity for GLC to resolve the issues by putting in place the measures that ought to make their actions. The question then arises, who are to be impacted by the current LI?
Yeah.
The backlog from 2015 to date, or the prospective students? If it's the prospective students, then the GLC is faced with the prospect of a floodgate being open for 3,000 people to swarm it, and they are afraid of that.
Right.
They are genuinely afraid of that.
Okay.
So what is the Supreme Court's ruling, and what is the interpretation?
As
That
far
must be
as far as
revisited.
we are concerned, this LI will pass. Then the problems will be solved. The other problems will be
It
solved
will
later.
pass because of the nature of subsidiary legislation. Because the LI as it stands doesn't appear to contravene Act 32.
Okay.
Section 13 and 14 of
Thank
Act
you.
32.
Thank you. Now,
But that's because you
I've
asked
heard
them to take it
I've
out.
heard you, Muntaka, suggest that this should not be allowed, and you are beginning to advocate for the students, and they are happy about you. Okay, you have joined those who say there's a shortfall of lawyers. We have not more than 3,000, just a little above 3,000 lawyers or so. It's actually not 3,000. We have like 2,000. 2,000. We have like 2,700 lawyers in the whole of the country, and out of the total number, 2,000 plus are here in Accra practicing here. And you say, because of that, the way to do it is what Professor Kokwasari and others are suggesting.
Yes.
So the LI should not pass.
In fact, I am impatiently waiting for the subsidiary legislation to finish. And I'm praying, I've been working very hard to be able to get to third of members of parliament to throw this thing away. Because look, we will be doing grave injustice to our own citizens, who we are representing. If you permit me, let me take just 1 minute to read the statement of Kwame Nkrumah when he was opening the Ghana Law School on January 4th, 1962. This law school, whose building I'm formally opening today, was founded less than 2 years after Ghana became independent to prepare students to become lawyers. The objective of the school is to give both full and part-time tuition in law so that those who had wished to become lawyers but who could not in the past afford the large sums required to study at the Inns of Court in London can now qualify. The lawyers needed in a developing state are, in the first place, those trained to assist the ordinary man and woman in his everyday legal problem, and particularly in the new problems likely to arise through industrialization. For example, lawyers are required by the trade union movement to assist in making effective agreement with employers and seeking to aid that the individual trade union is obtain what is legally due to him if he is injured at work or is illegally dismissed. In the same way, lawyers are required throughout the country so that in some towns and villages, inexpensive but very good advice can be had by the ordinary man.
That's okay. I mean, the Attorney General now says that even the state attorneys that are required,
yes,
all they need in excess of 600. But at the moment, they have about half that number.
I had not finished, but it just gives you the background.
Yes. No, it's not post-salary.
Looking at what the shortfalls that we have, and the method they are using, where's your O-level results? You probably don't even know why it is. Do you know why? By virtue of creating WAEC for you to write, I don't know whether you wrote SS or O-level. For those who wrote O-level, you write O-level to gain new entry into A-level for you to be able to write, to do advanced level education. The moment you get A-level certificate, O-level becomes useless. After passing very well with the A-level, it gives you entry into the next level, and then A-level becomes useless, and on and on and on. So today, even if you ask me where's my first degree certificate, it has become useless because all I needed was to take me to the next level, which I've managed to move to the next level. Believe me, the LLB that they are having.
When I entered the university, there had been a problem. The university needed to conduct entrance exams. We had to sit them before we enter.
We all criticize it, and where is it now? Are you still writing? Are they still writing? The same SSB, are they still writing? Because we said that that is unfair treatment. Because the person has already gotten what it must take him or her to cross to the next level. The situation dictated. No, it's not the stake. Let me show you. Look, when this faculty, when the school was established, you know that it was attached to University of Ghana Law School. It was supposed to be one body. Then for whatever reason, along the line, we decided to separate it. Okay. Let me tell you this and give you a practical example. Yes. That requires even human life. That requires even human life. The Medical and Dental Council certify every doctor that passes in this country, but they don't set up a school for you when you finish Legon or when you finish KNUST or UDS or Cape Coast for you to now come for them to do the training, the practical training for you. You do it with KNUST, but you pass their exams. Nurses and Midwifery Council, they don't set up another school for you when you have finished as a midwife or as a nurse to come for them to retrain you for the practical. It's the same school, but they make sure that whatever facilities...
Why don't you compare it to the doctors rather?
No, that's what I'm saying, the doctors. I've mentioned the doctors. I said that the Medical and Dental Council doesn't run a school for the practicals. The KNUST Medical School, the UDS Medical School, the Cape Coast Medical School, they are those who are running the practicals together with the affiliated hospitals. So that when you finish, then the Medical and Dental Council will now assess you and you write their exams and they say you are now a doctor. We are saying that go and do that. Stop this silo mentality. You are using it, believe me, look, and I'll say it here, and I want them to challenge
you. You say you are gathering how many signatures?
No, I need 2/3 of members of parliament to throw it out. And I'm very optimistic.
It's a very emotional
message. Like I said, Pharmacy Council, Pharmacy Council, they are dealing with human life.
Thank you.
No, some of their training, let me just say this, some of their training require corpse, dead bodies. So they need to have a mortuary.
Right.
They are doing it. Medical and Dental Council is not the one doing it. Okay, why should the legal, General Legal Council wants to be doing that clinical thing?
Thank you. The best street pocket lawyer in town. You want to make some...
Very brief.
Yes, very brief.
Yes, I'm going to disappoint you.
Okay.
Look, I vote for Professor Kweku Asari's line of thinking. That's where I stand. I haven't interrogated the thing thoroughly, but instinctively, sentimentally, that's where I drift to.
Okay.
I wonder what the executive itself thinks about all this.
They have petitioned the president.
Yes, I wonder.
In other words, you agree with Muntaka?
Yes, I do. Yeah. Well, and I pray Parliament does what he says. Yeah. Okay. That's what I have to say.
Okay. Yeah. Well, whilst the parliamentarians are likely, if they are minded to do so, and the president, if he's minded to intervene, the General Legal Council, all they are saying is that, well, it's money. It costs.
In the interim,
you should take care of it.
For now. Do you know why? Spin. Put all the names in the list and spin. You are taking 600. Let them come and pick. You are not writing any exams. Just come. Because we have 3,000 of you. In the meantime, what do? We put all the names. Okay. Yes, no. We put 600 yes.
But again, you must note that from what they say, if you shoot down this LI this year, they will not have. They will not admit the bank.
Is that a hint of a blackmail? Okay.